Good morning, and welcome to the second day of the special lecture series. For those of you who weren't here yesterday, I extend a welcome on behalf of the Law Society and on behalf of the Planning Committee for these lectures. This morning it's my privilege to introduce our first lecturer. The Honorable Mr. Justice Martin has had so distinguished a life at the bar and on the bench that it's difficult to know where to start in reminding you of his contributions to our profession. Following his call to the bar in 1938, His Lordship was a lecturer at Osgoode Hall Law School in criminal law, and for the next 25 years remained associated with the law school in one capacity or another. In his practice, he became the leading member of the criminal bar, defending spectacular and difficult cases with skill and effectiveness. His Lordship in practice was known not only as a master of advocacy, but also for his scholarly grasp of the substantive law. He was as at home before a jury as before an appellate court. His Lordship was elected a bencher in 1956 and then served as treasurer of the Law Society, commencing in 1970. He was appointed to the Court of Appeal in 1973, and he has served the province and the profession with distinction, interpreting and making law in what has become his familiar and characteristic style of clarity and compassion. This is the fifth occasion upon which His Lordship has lectured in this lecture series for the Law Society. This morning we are grateful and privileged to have him here. It's my honor to introduce you to the Honorable Mr. Justice Martin.
It's on your tie, just to...
You flip it on there?
Sure. I can get it straight.
Rocks, for your very kind introduction and for your very warm welcome. I feel much at home standing in this hall where I lectured for so many years. The subject of similar fact evidence is vast and indeed has been described as a morass, and more recently by Lord Hailsham as the pitted battlefield of similar fact evidence. The limits of time dictate that I should confine myself to some aspects of the subject only and to some recent cases. When I began to think of what I might say to you that might be of interest and of assistance, and refreshed my memory by rereading the more important cases and the recurring problems with which they deal, I thought of the maxim, plus ça change, plus c'est la même chose. The more things change, the more they remain the same. However, on further reflection, I am satisfied that our perceptions and insights into the admissibility of similar fact evidence have been sharpened by recent and important decisions of the courts and by the excellence of some of the literature on the subject that has appeared in the past several years. The frequent recurrence of old problems, whether in new or old guises, indicates, however, the need for all of us to keep the basic principles for the admission of similar fact evidence in mind. Almost 30 years ago, in 1955 to be exact, I was asked to participate in the Law Society's continuing legal education program on the subject of evidence. I was assigned the topic of character evidence, which included some discussion of similar fact evidence. 3 years before that, the important case of Harris versus the Director of Public Prosecutions, 36 Criminal Appeal Reports 39, had been decided by the House of Lords. The Judicial Committee of the Privy Council had a few years earlier rendered a very important decision in Nur Muhammad versus the King in 1949, Appeal Cases 182. In that lecture, two conclusions were drawn from those cases, which are not entirely easy to understand. The first conclusion was that before evidence of similar facts can be introduced against an accused, he must have been shown to have been connected with those facts. The third conclusion was that evidence of similar facts should not be admitted under the guise of rebutting a defense that is open to the accused unless that defense is reasonably open to the accused on the evidence. Both these questions have been the subject of recent decisions by the Supreme Court of Canada, which I will discuss later. Although the principles governing the admissibility of similar fact evidence are fairly easy to state, their application to particular factual situations frequently gives rise to difficulties. The language of Lord Herschel, Lord Chancellor, in delivering the judgment of the Privy Council in Macon versus the Attorney General of New South Wales, has always been accepted as enunciating the correct principle. And almost every judgment on similar fact evidence begins with a restatement of that principle. Lord Herschel said, page 65 of the judgment, in their lordships' opinion, the principles which must govern the decision of the case are clear, though the application of them is by no means free from difficulty. It is undoubtedly not competent for the prosecution to adduce evidence tending to show that the accused has been guilty of criminal acts other than those covered by the indictment for the purpose of leading to the conclusion that the accused is a person likely from his criminal conduct or character to have committed the offense with which he is tried. In other words, you can't introduce evidence simply to show that the accused is a bad man and therefore more likely than other people to have committed the crime with which he is charged. On the other hand, the mere fact that the evidence adduced tends to show the commission of other crimes does not render it inadmissible if it be relevant to an issue before the jury, and it may be so relevant if it bears upon the question whether the acts alleged to constitute the crime charged in the indictment were designed or accidental, or to rebut a defense which would otherwise be open to the accused. The first line of Lord Herschel's classic statement lays down a general rule of exclusion. Similar fact evidence or evidence of bad character is not admissible for the purpose of leading to the conclusion that a person is from his criminal conduct or character likely to have committed the offense charged. The exclusionary rule was said by Lord Sankey in Maxwell versus the Director of Public Prosecutions to express one of the most deeply rooted and jealously guarded principles of our criminal law. Such evidence is excluded not because it is irrelevant, because it is relevant, but is excluded on policy grounds, because the jury may give it more weight than it deserves, because its prejudicial effect may be more powerful than its probative value and endanger a fair trial by diverting the jury's attention from the real issues they have to decide, and because it tends to undermine the integrity of the presumption of innocence. The second proposition is that the mere fact that the evidence tends to show the commission of other crimes or to show that the accused is a person of bad character does not, by itself, render it inadmissible if it is relevant to an issue in the case, and it may be relevant if it bears on the question whether the acts alleged to constitute the crime charged were designed or accidental, or to rebut a defense which would otherwise be open to the accused. In Boardman and the Director of Public Prosecutions, Lord Hailsham emphasized that the second proposition was not an exception engrafted on the first, but is an independent proposition. The two propositions cover the entire field. If one applies, the other does not. But between the two, they cover the entire field. But in my view, it is of the utmost importance that the second principle, that is, the principle of admission, should not be interpreted so widely as to erode the first principle. Similar fact evidence is frequently used to negative coincidence or to show that an occurrence or an event resulted from design. The purpose of the evidence is to show the improbability that the act being investigated was the result of mere coincidence or accident. Its probative force is derived from what Wigmore calls the doctrine of chances, that is, the improbability of the recurrence of abnormal events by accident. That may be illustrated by reference to two of the leading cases. In Macon and the Attorney General of New South Wales, the appellants were charged with the murder of a child. They had undertaken with the child's mother to care for it for a very small sum, and its skeleton was found in the appellant's garden. Now, those facts are consistent with the child having died from natural causes and having been irregularly buried, or they are consistent with their having murdered the child to be relieved of the financial obligation of maintaining it. Evidence was given that a number of other children had been entrusted to the appellants for inadequate sums of money to maintain them, and that all these children had disappeared. Evidence was given that 3 additional children had been buried in the back garden of the appellants, where the skeleton of the deceased child was found. 6 children were found buried in the backyard of another house where the appellants lived, and 2 more in a third house where they had lived. That evidence was given to show the kind of business that the appellants were carrying on, in which the death of the deceased was an incident. The evidence with respect to the other children showed that the child, the death of which was the subject of the charge, had died by design and not from natural causes. How could a person wrongly charged with the murder of a child which had died accidentally be so unfortunate as to have lived at 3 different addresses in the back garden of which 12 children had been buried? The similar acts in Macon's case were introduced to prove that the appellants killed the child through the intermediate inference that the child died as a result of design, that his death was an incident of the nefarious business which the accused were carrying on. Once it was proved that the child died by design as opposed to dying from natural causes, the inference that the appellants killed the child is irresistible, as indeed was the inference that the child had died by design. The word accident is used in 2 different senses in the similar fact cases. As Viscount Simon said in Harris and the Director of Public Prosecutions, Lord Herschel's statement in Macon's case that evidence of similar facts may sometimes be admissible as bearing on the question whether the acts alleged to constitute the crime charged in the indictment were designed or accidental deserves close analysis. Sometimes the purpose properly served by such evidence is to help show that what happened was not an accident. If it was, the accused had nothing to do with it. Sometimes the purpose is to help to show what the intention with which the accused did the act which he is proved to have done. In a proper case and subject to safeguards which Lord Herschel indicates, either purpose is legitimate. Now, the word accident was used in the first sense in the Macon case to show that the death of the child was not an accident. So many accidents could not have occurred and really preclude any other conclusion. The famous case of Rexon Smith, known as the Brides in the Bath case, is another example of similar fact evidence used to show that the death of the victim occurred as a result of design and not by accident, which was against all probabilities. In that case, the accused was charged with the murder of Bessie Mundy, with whom he had gone through a form of marriage. She was found dead in her bath. Soon after, the accused had induced her to make a will in his favor. Evidence was introduced by the Crown that after the death of Bessie Mundy, the appellant had gone through a form of marriage with 2 other women, and that they both died in their baths in circumstances very similar to those in which Bessie Mundy died. The appellants also stood to benefit financially from their deaths. Now, the appellant's conviction for murder was upheld by the Court of Appeal, after what is described by the court as a very powerful argument from the great Sir Edward Marshall Hall. In the course of his argument, Sir Edward Marshall Hall objected to the charge to the jury by Mr. Justice Scrutton, and that charge is reproduced in the criminal appeal reports, or a portion that Sir Edward Marshall Hall objected to. Mr. Justice Scrutton seems to have exhibited a very keen perception of the relevancy of similar fact evidence in that case. And this is what he told the jury in part. You have to consider, have the prosecution satisfied you that Bessie Mundy was killed by the prisoner? Bessie Mundy dies under a series of circumstances which the defense say are quite consistent with an accidental death. And indeed they were, if you leave out the other two cases. The prosecution say you find that series of circumstances repeated in the death of Alice Burnham. And when you get two repetitions of the same act of circumstances, and I shall have to call your attention at the close of my summing up to the coincidences, you are entitled to find that an occurrence of this sort, which benefits the prisoner with these attendant circumstances, is design and not accident. And the jury have to take into account three things: the circumstances of the dead body and the way in which it is found, and the evidence they have as to the way it died, the opportunity of the prisoner to cause the death or not, the motive of the prisoner for causing the death. It may be that even then you are not sure whether it is an accident or design. And then comes in the purpose, and the only purpose for which you are allowed to consider the evidence as to the other deaths. If you find an accident which benefits a person, and you find that person has been sufficiently fortunate to have that accident happen to him a number of times, benefiting him each time, you draw a very strong, frequently an irresistible inference that the occurrence of so many accidents benefiting him is such a coincidence that it cannot have happened unless it was designed. The Lord Chief Justice interjected at this point. I think that puts it very accurately and states exactly the reason why the evidence was admissible. The hypothesis that Smith was so unfortunate as to have married three women, all of whom accidentally drowned in their baths, which incidentally he had installed, and whose death benefited him financially, is improbable to a degree that precludes rational acceptance. The only reasonable inference is that their deaths occurred by design, and if that was so, the only reasonable conclusion is that Smith killed them. Who else? The second limb of Lord Herschel's statement of principle in Macon's case stresses the purpose for which similar fact evidence in various categories for the admissibility of similar fact evidence have developed based on the purpose for which the evidence is sought to be introduced. These categories include the admissibility of similar fact evidence to show design, to negative accident, to prove guilty knowledge, to show a scheme or plan, or to rebut a defense of innocent purpose, and to prove identity. In Harris and the Director of Public Prosecutions, Viscount Simon, after stating that the principle laid down by Lord Herschel remained the proper principle to apply and that he saw no reason for modifying it, went on to say, in a very important passage, it is, I think, an error to attempt to draw up a closed list of the sort of cases in which the principle operates. Such a list only provides instances of general application, whereas what really matters is the principle itself and its proper application in the particular circumstances of the charge that is being tried. In Boardman versus the Director of Public Prosecutions, which has been hailed as an intellectual breakthrough by some writers, a decision of the House of Lords, the appellant, the head of a language school, was convicted of buggery with S, a pupil, and inciting H, another pupil, to commit buggery with him. The issue is whether the evidence on the count relating to H was admissible on the count relating to S and vice versa. The House of Lords held that the admissibility of the evidence depended on its degree of cogency and found the necessary degree of cogency in the existence of common, strikingly similar features in the facts narrated by S and H. Lord Wilberforce said, "The basic principle must be that the admission of similar fact evidence of the kind now in question is exceptional and requires a strong degree of probative force. This probative force is derived, if at all, from the circumstance that the facts testified to by each of the several witnesses bear to each other such a striking similarity that they must, when judged by experience and common sense, either all be true or have arisen from a cause common to the witnesses or from pure coincidence. The jury may therefore properly be asked to judge whether the right conclusion is that they are all true, so that each story is supported by the others. I use the words "a cause common to the witnesses" to include not only the possibility that the witnesses may have invented a story in concert, but also that a similar story may have arisen by a process of infection from media or publicity or simply from fashion. In the sexual field, this may be a real possibility, something more than mere similarity and absence of proved conspiracy is needed if this evidence is to be allowed. There being no evidence that the boys had concocted the story in concert, the evidence was held to be admissible, as similar fact evidence, because of the striking similarities in the common incidents testified to by the two boys. Once you eliminate the possibility of conspiracy or the repetition of a story that they have read in the media, it becomes in the highest degree improbable that if two boys were independently fabricating a false charge against the accused, that they would hit upon a fabricated story having each of them so many strikingly similar and common features. It really would be unreasonable to think that by pure accident that they could have described an event having strikingly common features if it was fabricated and if it was not caused by pre-concert. In Boardman, I should point out that, of course, you will have already observed that in the Smith and Macon cases, the facts testified to by the witnesses were really not in dispute. In other words, no issue arose as to the credibility of the witnesses deposing to the facts which the court concluded showed design on the part of the accused. The evidence in the Boardman case is used for an entirely different purpose. It's really given to support the evidence of the second boy is given to support the evidence of the first boy and vice versa, on the theory that I've indicated that it's inconceivable that two persons fabricating a story could, by sheer coincidence or accident, hit upon a fabricated story having incidents strikingly similar in common. And that was the principle on which the issue was decided in Boardman, which was a sort of a new dimension to similar fact evidence. In previous cases, an inference of design has been drawn from proved facts. In Boardman, an inference is drawn as to the truthfulness of the allegations from the common features of the common and strikingly similar features of the two stories, which is really not rationally probable if there was no pre-concert. Now, the issue in Boardman, as arose in the Court of Appeal, was in the House of Lords, was one of corroboration. Could the evidence of H corroborate the evidence of S, and vice versa? Now, the principle enunciated in Boardman has very wide repercussions. It's generally been thought, for instance, that on a charge of rape, although evidence of previous strikingly similar offenses committed by the accused can be introduced to prove identity, that evidence of other offenses committed by the accused is not relevant to consent. And generally speaking, the courts have excluded similar fact evidence on charges of rape where the issue is one of consent. But there's a very interesting case of the People versus Cassandras, which is referred to with approval by the Court of Appeal in the fairly recent case of R.V. Tierney. Now, in Cassandras, the facts were these. The accused was charged with raping Carmen Brown. Carmen Brown deposed to the fact that she'd attended at the United States Unemployment Office in San Francisco to obtain work. When she left the unemployment office, she was met by the accused, who, after seeing, I suppose, that she was somewhat downhearted, asked her whether she had got a job, and when she said that she hadn't, he said he thought he could get her a job as a soda fountain girl. And he took her ostensibly to a hotel where they were to meet the owner of the soda fountain, and at which point he required her to undress and have intercourse with her, saying that if she didn't, he would tell the police that she was a prostitute. Another woman was called who gave evidence that she had gone to the United States Unemployment Office seeking work, and when she got outside the premises, she was met by the accused, who thought he could get her a job as a soda fountain girl, and took her to a hotel where she was ostensibly to meet the new and prospective employer, and he told her to take off her clothes when she got to the room, expecting, of course, to meet the prospective employer, and that if she didn't, he would tell the police that she was a prostitute. Now, the trial judge, or the Court of Appeal in the People in Cassandra, recognized that normally the fact that A had intercourse with B without her consent does not prove that he had intercourse with C without her consent. And evidence of prior rapes is not relevant where consent is the only issue. But he held that the facts were so unusual as to show a design or a scheme on the part of the appellant to lure women to this hotel, and the rape occurred as an incident of that scheme. This was the basis upon which the Court of Appeal in Tierney applied the Cassandra case. And I think Cassandra does show a scheme or design. But there is another basis upon which the ruling in Cassandra can be justified. It's absolutely inconceivable that two complete strangers who never saw each other could have fabricated a story, such an unusual story, with the common incident of the threat to accuse them of being prostitutes, unless both stories were true. Now, change the scenario a little bit, that a number of women had been lured to this hotel and raped, and the newspaper published, or a woman had been lured to this hotel and raped, and the newspaper published a story warning women when they went to the United States Unemployment Office to seek employment, beware of a man who was waiting at the door and who promised them a job as a soda fountain girl, and who threatened to tell the police that they were prostitutes if they didn't have intercourse with him. Now, if following that notice in the newspaper, a half a dozen women came forward and said that this is what had happened to them, I question very much whether or not the evidence would be admissible on the basis enunciated in Boardman, that it was inconceivable that two different people could have fabricated a story having so many common and unusual features. I think it's well to bear that in mind. This would be covered by the example given by Lord Wilberforce, that you have to take into account that the story might have been concocted as a result of something that was seen in the newspapers. Now, as I have previously indicated, some eminent legal writers have seen in the Boardman decision the death knell of the categories, which we have previously referred to, and consider that the only issue is whether the evidence of similar facts is probative enough to justify its admission when its probative value is balanced against the inevitable prejudice to the accused resulting from its admission. It may be, I personally have not seen any evidence of it, but it may be that the categories of admissibility too often lead to a mechanical approach whereby if the evidence sought to be admitted fits one of the categories, that fact is seen as an automatic ticket to admissibility. Rather, a decision as to the admissibility should involve a balancing process to determine, in light of the issues and the other evidence, whether the evidence is probative enough to outweigh the prejudice caused by its admission. The categories, in that view, remain useful simply as illustrations of the governing principle, but they are neither shackles nor an automatic gateway to admissibility. The real test of admissibility is the cogency of the evidence, its probative value in the case, having regard to the issues and the other evidence in the case. In the recent case of Schweitzer and the King, Mr. Justice McIntyre, speaking for the Supreme Court of Canada, after referring to the words of Lord Herschel in Macon's case, said this: "Over the years, in seeking to apply this principle, judges have tended to create a list of categories or types of cases in which similar fact evidence could be admitted, generally by reference to the purpose for which the evidence was adduced. Evidence of similar facts has been adduced to prove intent, to prove a system, to prove a plan, to show malice, to rebut the defense of accident or mistake, to prove identity, to rebut the defense of innocent purpose, and for other similar and related purpose. This list is not complete. This approach has been useful because similar fact evidence by its nature is frequently adduced for its relevance to a single issue in the case under trial. It has, however, involved, in my opinion, a tendency to overlook the true basis upon which the evidence of similar facts is admissible. The general principle described by Lord Herschel may and should be applied in all cases where similar fact evidence is tendered, and its admissibility will depend upon the probative effect of the evidence balanced against the prejudice caused to the accused by its admission, whatever the purpose of its admission." This finds support in Boardman versus the DPP and is implicit in the words of Lord Herschel in the Macon case. The general principle enunciated in the Macon case by Lord Herschel should be borne in mind in approaching this problem. The categories, while sometimes useful, remain only as illustrations of the application of that general rule. The probative value of the evidence will frequently depend upon the other evidence in the case, and of course what the issues, the viable issues, are. A good illustration of this is in Thompson versus the Director of Public Prosecutions. Now, in that case, the appellant was convicted of gross indecency committed with two boys on March 16. The man who committed the offense with the boys made an appointment to meet the boys again on March 19. Both boys went to the appointed place, and the appellant appeared at the appointed place and time and conversed with them and gave them some money. The police who had been informed of the events were present to watch and arrested the appellant. The appellant denied that he was the person who committed the offenses on March the 16th and said he was elsewhere. He said that on March the 19th, that's the day he was arrested, he was pestered by the two boys and he gave them a coin to go away. The appellant was in possession of articles said to be used by homosexuals, and photographs of naked boys were found in the locked drawer in his residence. The evidence was held by the House of Lords to be properly admissible on the following basis. The appellant's defense was that he had been mistakenly identified. The House of Lords held that in view of the appointment made on March 16 by the man who committed the offense, whoever he was. For the 19th, it would be an extraordinary coincidence if the man who showed up at the appointed time was in fact a homosexual, if the boys had mistakenly identified. That would have been an extraordinary coincidence. And the evidence was admissible on that basis. Some of the broader statements made by Lord Sumner with respect to homosexuality being a psychical characteristic like a physical characteristic by which homosexuals are more readily identifiable can no longer be supported in all its implications. In other words, if a person is charged with a homosexual offense, the prosecution cannot automatically introduce evidence that the accused is a homosexual. That fact is relevant, but it's not relevant enough to justify its admission. Now, I think I should point out that the rejection of Lord Sumner's statement that homosexuals have a psychical characteristic identifying them as members of an abnormal class simply means that the similar fact evidence has no special rule related to homosexual cases. The evidence, whether it's a homosexual charge or not, has to be probative enough to justify its admission. The mere fact that the accused is a homosexual doesn't permit evidence to be given of his homosexuality if he's charged with an offense involving homosexual conduct. Now, that principle doesn't at all impair the judgment of the Supreme Court of Canada in Lupien versus the Queen. In that case, the accused was charged with a homosexual offense, and the Supreme Court held that he was entitled by psychiatric evidence to show that he was not a homosexual and had a behavioral incapacity which precluded his participating in a homosexual act. Now, in order for the prosecution to adduce evidence of similar facts or prior bad conduct, the evidence must have high probative value in order to outweigh its prejudicial effect. The accused isn't confronted by any such limitation. He can introduce any evidence, however slight its value, which tends to show that he is innocent. And if he is charged with a homosexual offense, he can introduce evidence to show that he is not a homosexual. He's not a member of the group. This evidence isn't cogent enough when introduced by the Crown, but certainly the accused is not precluded from introducing it. Now, in Boardman, striking similarity with respect to the common features of the facts narrated was essential to the admissibility of the evidence on each count, on the other count. Striking similarity, however, is not required in all cases. It depends upon what the evidence is being introduced for. Now, where the only evidence identifying the accused as the perpetrator of the crime is the commission by him of other crimes having the same common or unusual and distinctive features, a very high degree of similarity is required. A very high degree of similarities common to both crimes is required. In the King and Straffen, the accused was convicted of the murder of a little girl who on April the 29th, 1952, had been manually strangled but not sexually assaulted. There was no evidence of any struggle or that any effort had been made to conceal the body, although it would have been easy to do so. Now, the accused had been previously charged with the murder of two other little girls. It took place some 7 or 8 months before. He had been found unfit to stand his trial and had been committed to Broadmoor. He had escaped the day that the little girl with whose murder he was charged had occurred. There was no evidence, and he was recaptured the same day, but he was at large at the time of the murder of the little girl. Now, there was no evidence whatever connecting Straffen with the murder of the little girl with whose murder he was charged, other than the fact that he was in the vicinity, which, of course, wouldn't carry the case very far. But the accused admitted killing the two other little girls, and they had been killed in exactly the same way. They had been manually strangled. There was no motive, no attempt at sexual molestation, and no effort made to conceal their bodies, although it would have been easy to do so. And the court held that the common striking characteristics showed that the offenses were committed by one person, in effect. And the person who committed them was Straffen, who in effect had left his signature on all 3 crimes. It would have been an extraordinary coincidence if, while Straffen was on the loose in that area, there had been another madman in that area who, without motive, killed little girls in precisely the same way that Straffen killed them. I don't think that is a reasonable probability. But striking similarity is not a condition of admissibility in every case. It depends, as I say, upon what the evidence is introduced for. Sir Rupert Cross indicates that striking similarity is not essential to negative ignorance or to show absence of intent. And I think that he was quite correct in that respect. Suppose you have this situation. A man is charged with uttering a counterfeit $20 bill, and it is shown that he went into a shop and tendered a $20 bill, bought a small article, and got $19 in change. Now, he might have got that $20 bill innocently and unwittingly passed it off. But if you found that on the same day he went into another shop and purchased an article for $1 and got $19 in change, which he pocketed, I suggest that that evidence is probably probative enough to show that he did not unwittingly pass off the $20 bill in the first case. If so, when he bought the small article in the second shop, why didn't he tender some of the change rather than presenting a $20 bill? Now, there's nothing strikingly similar about those 2 instances. For all I know, that may be the usual way that people get rid of counterfeit money, going to one shop, tendering a bill for a small article, getting good money in return, and proceeding on to the next shop. But has not that sufficient probative value to justify its admissibility? In the dredging case, which was decided by the Court of Appeal now 3 years ago, the facts were these. The accused were charged with conspiracy to defraud various public agencies. And the system, the underlying facts were these. It was proved, I think, beyond question that a number of people in the dredging business got together to submit false bids. It would be agreed beforehand who would be the low bidder, and it would be agreed beforehand that the other persons would bid high or not bid at all, and then a sufficient amount would be added to the low bidder's contract to pay off those who had accommodated them by bidding high. They would be paid off either in cash or by being allowed to be the low bidder on some other occasion. Now, evidence was given by 3 senior officials that some presidents of companies were aware of the bid rigging that was going on in the industry. But the Crown, in order to support their evidence in that, introduced evidence of 38 additional cases of bid rigging in addition to the 7 counts charged. And the Court of Appeal, while questioning whether there was any striking similarity about the similar facts, held that at least there was an underlying unity, and the evidence was admissible, tending to show guilty knowledge, and that striking similarity was not essential for that purpose. Now, the judgment in the dredging case is a very large judgment. It's about 350 pages, but it has a very good index, and I think the section of the judgment dealing with similar facts is extremely valuable and well worth reading. I think it tends to be overlooked probably because of the fact that it's buried in such a big judgment. Now, I think I'm running over my time a little bit. I had a lot more to talk to you about, and Mr. Rock, should I wind this up now? and it'll all be printed anyway. And well, then let me just leave you with this note. I will not have time to deal with all the matters that I want to talk about. It's difficult and perhaps too early to assess the effect of the recent decisions emphasizing that the categories of relevance which have developed with respect to similar fact evidence are mere illustrations of the general principle, and emphasizing that the admissibility of similar fact evidence depends upon it having a high degree of probative value, and also upon a balancing process in which the probative value of the evidence is weighed against its prejudicial effect. But it must be remembered that almost 35 years ago, Viscount Simon articulated very nearly the same principle in Harris, when he said there would be a mistake to contemplate a closed list of cases in which the principle enunciated in Macon applies, and such a list only provides instances of the application of the general rule, and further said, evidence of similar facts should be excluded unless such evidence has a really material bearing on the issues to be decided. I think the teachings of the recent decisions is that a mechanical approach to the admissibility of similar facts is to be avoided. Slotting the proposed evidence into one of the categories is not an automatic ticket to admissibility, if indeed it ever was. But the evidence must have a high degree of probative value. But to justify its admission, having regard to the inevitable prejudice of the accused if it's admitted. Having said that, I think that the categories, if only as illustrations, will continue to have considerable influence. They developed as a result of long experience and not as arbitrary or irrational rules. And they will continue to be useful illustrations of most of the legitimate uses of similar fact evidence. But has already been said, they do not impose shackles, and they are not an automatic ticket to admissibility. But I think they're far from dead. Thank you very much. I forgot that I was shackled. You got me loose from this equipment. Thank you very much.
My name is Eric Gertner, and I have the privilege of introducing the second speaker on today's program, Jane Arnup. Jane Arnup received her law degree from the University of Toronto in 1979. She was called to the bar in 1981, and already in that brief period that she's been an advocate in this province, she has earned quite a reputation for herself. I myself have had the benefit of her wisdom and knowledge as a legal research officer for the Ontario Law Reform Commission, where Jane worked some summers. She has already participated in a number of continuing legal education programs conducted by the Law Society of Upper Canada. Her topic today is entitled, Has Caution Been Thrown to the Wind? The Aftermath of Vetrovec.